Colin O'Keefe here for LXPN TV. There's an interesting ballot initiative circulating in California, and yes, though it is just a ballot initiative, it is quite fascinating as it would make all personally identifiable information of consumers automatically confidential and could set quite the precedent. Joining me to explain is Jake Romero, attorney in Mintz-Levin's San Diego office and author on their blog, Privacy and Security Matters. Jake, first, can you explain the basics of this ballot initiative?
Right, absolutely, Colin. So it is interesting. What the ballot initiative would essentially do is establish an opt-in requirement that goes well beyond the requirements of any of the other states currently. So the initiative, which is being referred to as the California Personal Privacy Initiative, would create a presumption that a person's personally identifiable information would be confidential. And if any business or government entity wanted to share that information, they would be required to either obtain that person's authorization beforehand, or they would have to fit within a very narrow exception where there's a compelling countervailing interest. So this is a big deal for a few reasons. The first is that the definition of personally identifiable information is quite broad. It's anything that can be used to identify a natural person, whether on its own or when linked with any other information that can be linked back to that person. The second reason this is a big deal is because the reality is that most online services don't do everything in-house. They utilize third-party service providers, whether it's a payment processor, backup services, or hosting. And as it currently stands, you can share that information for those purposes so long as you put it in your privacy statement and disclose that you've done it. If this initiative gets put on the ballot and is adopted by the voters, then there will essentially be a pretty expensive transition period where businesses will have to figure out, one, how do I implement an opt-in system? And two, how do I take my current users and swap them over to this new system?
It's very interesting. And then the second part here, the part that really piqued my attention, is the fact that the ballot initiative included, quote, a presumption that a person has been harmed if his or her information has been disclosed without his or her authorization. And really, that's been a big component in all the data privacy litigation I've seen, as someone may sue Sony for losing credit card information or Apple for its Safari browser collecting data that it shouldn't have. People sue and say that the company shouldn't have done this, but the court says yes, but you can't prove that they'd actually harmed you. Can this part of the ballot initiative be challenged, or is this really as big of a deal as it seems?
No, this is a huge part of the initiative. So even just earlier this year, in a case against Pandora Media, a plaintiff argued that the sharing of his data by Pandora had diminished the value of his personally identifiable information and had exposed him to the risk of future harm. And the court there held that the risk of future harm was not sufficient for standing, and the facts in that case weren't sufficient to prove that the value of his information had been diminished. Here, what the initiative would do is create a presumption that the person had been harmed if their information was shared in an unauthorized way. So the plaintiff wouldn't be required to prove harm any longer. It would be the defendant that would have to prove that the plaintiff was not harmed. The big second shoe to drop on that would be that this would make it much easier to bring class action suits within the realm of data privacy. As far as it being challenged, this ultimately would be a question of how the courts interpret it. But it's important to note that this is coming up at a time when the issue of the power of the courts and the legislature in California with respect to voter-approved initiatives is a pretty hot topic within the state. It's just one of a few reasons why it's really, really interesting that this is being done as a ballot initiative, and it makes it a pretty compelling case.
This is going to be fascinating to watch, and I can't say it enough. It is just a ballot initiative, but if this keeps moving forward and picks up some momentum, it could be quite powerful.
Absolutely. It is worth noting that, the signature gathering requirement in California is expensive and it's burdensome. So, who knows? Right now it's being considered by the attorneys general. It will probably need a fiscal note, and the number of signatures that it will need to gather before it actually gets on the ballot is pretty high. That having been said, this is something to keep an eye on.
Absolutely, absolutely. Once again, that was Jake Romero. He is an attorney in Mintz-Levin's San Diego office. If you're looking for more of his insight on this ballot initiative, be sure to visit privacyandsecuritymatters.com. And of course, if you're not already watching us here on LXPN, visit lxpn.com, where you can find more curated commentary from the LexBlog Network's more than 8,000 members, along with hundreds of these LXPN TV video interviews. Thank you for joining me today, Jake.
Oh, thank you. It was a pleasure.